Oops.
No, you're good. That's the first page. Okay, I'm going to make a suggestion. You don't have to follow it, okay? You have the slide presentation there with you, and it's going to be up on the screen. I'm going to be talking about specific provisions in the contract. That's why we provided you with the contract. My suggestion is that you focus on the contract and not so much on the slides, because you can take those home with you, okay? Just use those if a question comes up so that you don't forget, all right? So we are going to start right on page 1. Alex, I can't move it now. Oh, here, let me go down here. Okay, first line, okay? The deed is the best source of your information. So you represent a buyer, you're getting ready to put in an offer, and we're going through the FAR bar as is. It is currently the most commonly used contract. That reflects the booming real estate economy. I'm sure at some point we'll go back to the other one, but this is the contract that's used most often. What I see, the sellers. For those of you who are listing agents, before you go on that listing appointment, pull up the information on the property appraiser's office and then look for the deed. It's all public records. Click on the deed, the last recorded deed. That deed will tell you who the owners of the property are, okay? If you have a listing agreement and that listing agreement only has one of them, you don't have a listing agreement, because one can't sell the property without the other, okay? I have seen that a lot. So start with the deed. The names that are on the deed are the names that you will put on line 1 where it says sellers, line 2, buyers. And here's where it gets a little tricky, because the buyers, okay, you know their names, they're husband and wife. Here's one that I hear all the time. Well, but it's only, my husband's the only one that's going to be on the contract and on title because they're only using his credit. And so the wife's name can't be on the deed. Wrong, okay? Ask them how they want to hold title. And if they start asking you questions that start to kind of walk over legal issues, you need to be careful. Do not engage in the unauthorized practice of law. Have them contact an attorney. Most of you know, I'm happy to talk to anybody for questions like that. I do not charge. Everybody here, I think, knows that, because it has, you didn't hear that. No, because it is very important. Your title agent has to go by what's in the contract. So that information is critical. There are a lot of title agents out there that if you show up at closing and suddenly tell them that you want husband and wife, but the contract is only in the husband's name, all the documents have been drafted with the husband, okay? Just because they're using the husband's credit does not mean the wife cannot be on the deed. So just be very careful. Communication with your clients is the absolute key in really in handling the transaction from the beginning, but especially in dealing with the contract. So the deed is always the best evidence. You can look at the information in the property appraiser's office, but to confirm it, you need to look at the last recorded deed. Here's another one that's my favorite. I hate electronic signatures. I know we're going to complete electronic closings. I know we're practically there. However, please be very careful, okay? For those of you who are new, if you have husband and wife own the home, you've only ever spoken to wife, husband is away on a trip, you've never seen husband. Who signs the contract? Oh, you get electronic signatures from both. Please make sure that you have at some point in some fashion spoken with that spouse who you have never seen. Get a driver's license, a passport, I don't care, some kind of official photo ID. Why? You know all those stories we hear of the scorned wife who decides to sell that Ferrari for $1? It happens, okay? It absolutely happens. And with electronic signatures, look, well, he left now, but he or I, for each other, can create an email account. We know all of our information. We know all the passwords we use, or we can create one because, hey, I'm going to be the one signing, and you will never know because the verification process, it's only through your system, and it's based on the information that the first person put in there, okay? So just be careful about it. 9 out of 10 times, there's gonna be something in your gut. Something is gonna be telling you that something isn't right. Don't ever ignore that. It's gonna save you all the time, okay? Next, confirm the street address. Make sure that you have the correct street address. Again, keep in mind that this contract goes to your title agent, and everything they do is based on that information that you include in there. Make sure it's accurate. That way there aren't delays in ordering a title search. The legal description, I know some of them are, you know, an entire page long. Either see attached and you can print it right out, attach it to the contract. You can print it from the property appraiser site, or write the shortened version of that. Okay, now we're gonna get into the fun stuff, nitty gritty. You guys need to, once again, really communicate with your clients. So when you look in first paragraph, subsection D, personal property, okay? And we're focusing on lines 20 through 21 and 23 through 24. That's what we're gonna be talking about right now. So everybody needs to know personal property is automatically included in the sale of the property, okay? Unless you specifically exclude it, okay? So that beautiful chandelier that's sitting in the foyer or in the dining room that the seller is not intending to part with, you need to make absolutely certain, and putting it on MLS is not sufficient, okay? MLS does not form a contract. That's just information that you put out there. It has to be in the written contract that is signed by buyer and seller. My recommendation, and again, for those of you who are new, I teach best practices. So my classes are very different from probably everybody else. I love hearing from you guys, but I love getting the phone calls before you make a mistake. Kim's nodding her head. It just, because by the time that something bad has happened, I don't like to be the bearer of bad news. I don't like for you to be in trouble. Your client's not going to be happy when it's something that can be easily preventable. So here's my advice. Best practices on personal property. You're a listing agent. You walk through the home with your client like a hawk, looking at absolutely everything that is there and asking, or is this staying? Are you keeping this? Is this going or staying with everything? Pay attention to the chandeliers, the window treatments. One that I wouldn't have thought of, multiple refrigerators, okay? Years ago, the contract said refrigerator, one, right? So everybody, for the most part, took the one in the garage, or they swapped it out, put the one from the garage inside and took the nicer one. The contract says refrigerators. If there are 2 refrigerators in the home, a wine cooler, and a freezer, there's a good argument that all of that goes. The 2 refrigerators, 100% in fact, they go. Be careful with the wine coolers, okay? They oftentimes are made to look like they are part of a built-in system. Best practice, if you represent the seller, ask the question, what are you doing with this? Are you keeping it or selling it? If you represent the buyer, as you are walking through the property, ask the buyer, this is a wine cooler. Do you want this? And then what are you going to do when you make your offer? You're going to write in there exactly what you want, what your buyer wants. There's no gray area when you operate that way. Okay, so you have to be very meticulous and very thorough as you're going through everything that's in there. Okay, flat screen TVs or the plasma TVs. More than I ever thought I would know about them. Here's the deal on those. The brackets are affixed to the property and they stay. The TV, and there is a case on this, I found it because I had a client that I represented and it was an issue involving a wine cooler that looked like it was part of the built-ins. Anyhow, the TV is personal property that it is actually excluded. Whatever's affixed, that's included. So here, don't even get into it. TV does not convey. If they want the brackets don't convey. You know, the seller can decide what they want to include or not include. It just needs to be in the contract. Purchase price. Okay, that one's easy, right? What is the price that everybody agrees to? Okay, make sure you put that in there. Here's the important part, okay? The escrow deposit. And this is a part that even I didn't spend a lot of time on this before. Why? Because it seems so simple. It's plain and it's simple, but have to pay attention to it. If you represent the buyer, if that escrow deposit is not accompanying the contract, that escrow deposit must be provided to the selling agent, the escrow agent within 3 days of the effective date of the contract. If that is not done, the buyer is in breach of the contract and the seller can just walk away because buyer breached first. Be careful. On the flip side, if you're representing the seller, dog that. Stay on top of your escrow agent, your title agent. Ask them every single day. Why? When you get that feeling something's not really right, you just get that sense, yeah, I don't know about this buyer. 9 out of 10 times they never make that deposit. Realtor doesn't follow up. Title agent didn't let anybody know. Now 3 weeks have gone by. Nobody's heard from anybody, and it's at that point that you're going to have to explain to your seller why their property was off the market for 3 weeks, and you had no idea. You need to make sure that you get the verification of escrow funds from the title agent, okay? When you're going through and completing that subsection A, here's the part that I never paid attention to. The Florida Administrative Code governs realtors, okay? FREC is your watchdog. If you have a broker that holds escrow, broker is subject to different rules. The broker holds the escrow and on. There's not that many brokers that do it nowadays. I don't recommend it for any brokers in here. Unless you like having FREC visit you a couple of times a year, just have someone else hold it, okay? Those lines, it specifically says escrow agent, okay? I know that on MLS, you write the information right at the bottom in the instructions, who to put on there. As the listing agent, be careful with the information you are providing. According to that Florida Administrative Code provision, the only information that can go on that line is the name of the title company who is acting as the escrow agent, or an attorney if an attorney is acting as escrow agent. No other names. Definitely never put down a marketing representative's name on there. The only time an escrow agent can be named without the title company, and that's kind of a, you may get dinged, but it might just be a slap on the wrist, is if in fact they are licensed and they have the ability to sign on the escrow account. Title companies get in trouble for that if they're audited. It's a violation. My concern, most importantly, is protecting you guys. So you have to be careful what you put in there. If you represent the buyer, listen, pick up the phone and ask. If you see a name on there, pick up and ask. You may not know that they're an attorney and that's why it has a name. Just ask, look them up. The information on there has to be, just like I said, title company or attorney. Phone number has to be the main office number. The email has to be an email that is connected with attorney's office if they're holding escrow, or the title company, okay? So be mindful of that. It's not something that's typically covered and therefore allows itself for mistakes. Okay, purchase price, additional deposit is the next one, okay? Lines 35 and 36. Here's my suggestion to everybody, and I've been seeing this a lot on a lot of the Facebook groups, the question, you know, what's a standard deposit? Listen, whatever you agree to. I typically see $1,000. If you're selling a $600,000 home and they're putting down a $1,000 deposit, if the seller agrees to that, okay, I've seen it, okay? But here's where put your money where your mouth is, right? After the inspection, at that time, make an additional deposit. If there's a financing contingency, the entire amount is still fully refundable, assuming the buyer did things the way they should have, but it makes your offer look stronger, okay? Because you may have only had $2,000, but after the inspection period, the additional deposit can be $5,000 or $10,000. Now suddenly that becomes a much more attractive offer. Another one that I see a lot, please complete the information in there. I see a lot of folks who just fill in the purchase price, the deposit, and the rest of, and the escrow agent, and the rest of it is blank. Don't do that. Fill it all in, okay? If you have questions, usually it involves a little bit of math. It's not a whole lot. It can, you know, but just, if it's a cash deal, it's a cash deal. So what do? 100 grand minus $1,000 deposit, $99,000. The amount that you put on here, the final dollar amount, has nothing to do with the total amount due at closing. It does not reflect the title company charges, the owner's policy. It doesn't reflect any of that. Prorations, none of that. It is just strictly relating to the purchase price. So don't worry about the rest of it, but fill it in. It does make a difference, guys. Okay, one thing, and it is in bold in the contract, and it is on line 42, the definition of collection. And this is one of my pet peeves, because I don't like seeing things in the contract that require you to flip to the end of the contract, because most people, not just realtors, most people, human nature, you're not going to flip, okay? You're not going to flip the page. The funds have to be collected. What does that mean? The funds have to be available, okay? Collected funds. Some banks, the funds will be available the next day. Others, for whatever reason, depending on where funds are coming from, even if they're wired, the funds may not be available until 3 days, okay? Collected is at that point, okay? Just so you know, that's what's on standard S. Then paragraph 3, time for acceptance. Okay, it's easy for the buyer to make the offer and the seller to know when they have to accept, right? Because you put in a date. You can even put in a time, okay? And by the way, you're putting in a specific date. Under this contract, we count calendar days, okay? Every day counts. If the deadline falls on a weekend or a holiday, for most things, there's always an exception. For most things, it gets bumped to the following Monday or regular business day at 5 o'clock. Make sure that you fill that in with a specific date and time. If the seller does not respond to your offer, here's the deal. The offer is rejected, okay? I am starting to get a lot of calls and emails, but I was talking to the listing agent, or I was talking to my client, and my client said he was going to make an offer, or he was accepting it even if it was 5 days late. Guys, meaningless. The only thing that matters is what is in writing, signed by the buyer and the seller. The conversations that you have with the other agents mean nothing. You guys are not a party to the contract, okay? Even though there's a line towards the end for who's the listing agent, who's the buyer, the selling agent, you are not a party to the contract. The only parties to the contract, buyer and seller. So what do? Seller hasn't responded. If they tell you, selling agent or listing agent says, you know, they've been out of town, but they want to counter, they're going to counter in a couple of days, you know what? Take the extra step. Send the contract with a new date. I know it's work, but it avoids a lot of problems down the road, okay? And that's the correct way of doing it. You stop and think about it. Your buyer may be telling you, fine, yes, I'll wait till Friday. So I'm gonna do examples here, okay? Kim tells Erica, oh yeah, bless you. My buyer is fine. He says, no problem. Erica's all excited. Yes, the seller's coming into town. He wants to counter. I think we're going to be able to make this work. Seller comes on Friday and counters, and the counter barely made a change. It was full asking price. Maybe he needed an extra week for the closing date that needed to be changed. Erica gets that contract right back 11 o'clock at night on Friday, because that's when the seller got into town. Guess what? Buyer doesn't have to sign it. Now, Kim, if the buyer changed his mind, Kim has to tell Erica, I know I told you it was fine. I'm really, really sorry. He won't sign. He won't accept it. You have no recourse, okay? So if your client on the listing side is out of town, can't meet the deadline for whatever reason, force the buyer's agent to send over a new contract with a new date. Guys, it's all saved in whatever program you use. It probably takes less than 2 minutes to go in and change that date. You need to have your client sign it, okay? Now, the one that is kind of tucked away is the counter offer. If the seller makes a counter offer under the terms of the contract, okay, and that is on page 1, lines 46 through 47. That counter offer is valid for 2 days. It is written in the contract. I had somebody ask me, and actually when I first realized, this is a good teaching point, a very, very successful broker with a ton of experience who's on top of everything and knows that contract, okay? He calls me, he goes, is it really 2 days? Because he had like $1 million, $2 million condo on the beach and competing offers, and he made a counter. Meanwhile, a better offer came in for cash and his seller wanted to back out. You can try, because what I hear and what some attorneys may tell you is, oh, you can rescind that offer at any time before it's accepted. Guys, there again, best practice, don't put yourself in that position. That is a battle that is really not worth fighting. I can argue both sides of that, but my opinion on that, my 27 years of being a trial lawyer tells me you're going to lose. If you try to shorten that time period, you're going to lose. So what do? And I think it's not as big an issue right now because I don't think there's as many competing offers. But if your seller, make sure you point it out to them. Because remember, most of what you need to do is manage your client's expectations, right? That's one point where you need to talk to them about it. Let them know, hey, you're making this counter offer. It sits there for 2 days. If you get a better offer in the meantime, you can take it as a backup offer, but you can take it, but you still have this offer out there. And if that buyer accepts it, you have to go with that one. If he only wants to have it valid for a day, most people know within a day. I mean, how many people here does it actually take 2 days when you get a counter offer to get it accepted, rejected? Rarely. If they want it in just 1 day, if they want it in 6 hours, it doesn't matter. You can change that 2-day period under the additional terms. Here's one. I hate the additional term section, but I will tell you, this is a factual statement. You can write down facts. Factual statement. This offer remain, just take the words right out of the contract, exactly the same for 1 day through whatever, November 7th at 3 p.m. You can get that specific. Now you've protected your seller, okay? So just be aware of that. Effective date. Under section B. Guys, lines 48 through 49. This has changed over the last 5 years or so. The effective date under this contract, the CRISP contract has a specific date that you write in there. I know folks like that. This contract does not, okay? And I will tell you on the committee, we visited that issue. However, there are a lot of problems with putting in a specific date because if you, the buyer, make the effective date of the contract November 10th, and that's valid because it is a Sunday, but that's okay. The effective date is November 10th, but November 10th, November 9th is the day that you have sent that offer to the seller. The seller doesn't sign the contract, or you don't have a final agreed upon contract until November 14th. Now what? You have no real way of guessing the date, and so on the FAR bar contract, I really, in the foreseeable future, I don't see us adding a blank for a specific date, okay? So when the effective date starts is when the last one signs and the contract has been delivered, okay? Delivered is it has been delivered to the buyer's agent in most cases. I'm just taking the typical, there's an offer that's made, seller accepts, and it's sent. Guys, if it's in your inbox and you just decide you're not gonna open it, guess what? Effective date is the date that that email was sent. It is not the day that you opened it. For those who, and I think there's still a few, who want to have a written document, written paper, and they hand deliver it to your office. And nowadays we all work remotely, right? Just because you don't show up in your office doesn't mean that the effective date isn't the day that they walked in and put that contract down. So be very careful with that. Best practice, okay? Here's what you need to do. This is the most critical date in the contract. So when you have a signed contract, you are going to, I'll provide you with a form. Start with the effective date. Have all the critical dates, the inspection deadline, because you count from there, right? And I get the question, is effective date day 1? No. Effective date is date 0. The next day is day 1. Okay, so that's how you start counting. You count all of the days. If the inspection deadline falls on the weekend, that gets bumped to Monday or the next business day at 5 o'clock. For everything else, you get midnight. Don't get confused on that one. 5 o'clock if it's a deadline that's been extended just because of a weekend or a holiday, okay? Put that down. Just create your list. You've got effective date, inspection deadline, loan application, which is usually even before that, 5 days in, all of your deadlines down to your closing date, okay? Yes, you're doing the work for the other agent, but you're really doing yourself a favor. Immediately when you get that contract, or if you're on the seller side, just do it, send it to the buyer's agent with all those deadlines, with an email confirming specifically the effective date of the contract and the other deadlines. Why are you doing that? To make sure everybody's on the same page. If the other agent thinks that the effective date is something else, that's their time to speak, right? So make sure in that email you say, if you disagree with any of the dates set forth here, you know, don't even use legal terms. If you disagree with any of these dates, please contact me immediately in writing, okay? Don't use the he said, she said, to figure it out. At the beginning of a deal, everybody wants to close. The realtors, everybody wants their commission. Buyer wants to buy, seller, most of the time, actually wants to sell. So it's the best time to straighten those deadlines out. And you're doing yourself a favor because now you have an easy guideline. You can stay on top of those deadlines because now you have that cheat sheet, if you will. But you avoid a lot of problems down the road with missed deadlines, okay? Which is still on, we're still on page 1. Okay, that's a date. It's lines 50 through 52. Whatever you do not leave that space blank. There are certain terms that are material terms to the contract, okay? Purchase price is one, closing date is another. You know, the parties, purchase price, closing date. Everybody's heard you can literally have a contract on a cocktail napkin. That is valid as long as everybody signed it and it has the critical terms. You don't have the closing date filled in, you don't have a binding contract, okay? I often see on or before. That's just, you know, if you're able to close before, I've never seen someone when everybody's ready to close who's gonna complain about it. I mean, that's just done by agreement. It doesn't really mean anything, but if you wanna add it in there, go ahead and add it in there and then they can, you know, close early, all right? Now, the closing date is actually a very critical date as far as liability for anything that happens with the property. On that closing date, so seller owns the property through the day before that closing date. Buyer is the owner of the property on the closing date moving forward. Okay, just think about it as they prorate the taxes. That's how they prorate them. So you have a closing date. Everybody signed all the closing documents and lightning strikes an air conditioner, true story. Who's responsible? And there were other facts in this case that I had, but who's responsible? Who said buyer over here? Buyer's responsible. He owns the property. Closing date, and it doesn't really matter. Closing didn't happen until 5 o'clock, and that lightning strike was at 3 in the afternoon. I'd like to see that lawsuit. Talk about, you know, that it is the day. You don't get your prorations for taxes based on the hour. It's based on the day. So starting at 12 a.m., that is the day that the buyer owns the property for the closing date. Okay? Mail away closing. That was my example. Okay. Are we doing on time? We good? Okay. Page 2, extension of the closing date. Okay. Again, I can't stress this enough. The closing date is the most important date. It is critical, okay? If you think, you guys always have to be listening, okay? Not just to what your clients are actually telling you about the transaction, but pay attention to the stories they're sharing with you. You know, when you're having that chit-chat conversation, pay attention, because they don't know what they don't know, and they don't know, like you do, what's important and what's not. So within that conversation, you actually hear something and think, wait a second, that doesn't make sense. The closing date is over here. I don't think that they have to make sure they know. If you think you need an extension, deal with it right then and there. Do not wait till the end. Again, you need an amendment to the contract. Guys, on Form Simplicity, go on Form Simplicity. They have a form for the extension of the contract. That form, and I'm not usually singing the praises of a lot of the forms in there, however, this form is a wonderful form because it actually allows you to put in the new closing date, but it walks you through all of the other issues that may come up. Why do I like it? Because it forces you to think. Read that, okay? Because it might trigger something. I had a situation where there was an extension to the contract. Listing agent didn't use the form. I, of course, get the phone call. But I had all these conversations with the seller, and he agreed, and he did. I'm really sorry. He got lucky that the buyer needed an additional extension. And so what the seller had told him the first time around was he would agree to the extension, but without any seller concessions. The listing agent had an amendment to the contract that was just, you know, the one-page form that you guys can go to town on. Yeah, just extending the closing date and said nothing else. Had he used that other form, he would have, it would have forced him, because it walks you through all of the other things that may need to be extended. And then at the bottom, it has a spot for other. Okay, so use that form. Don't wait until the end. Okay. Okay, we don't really deal with this anymore, but the 10-day extension in 5A, that was put in there when the CFPB first came into play, and nobody really knew how long things were going to take. And the lenders had to provide that 3-day period so that the buyers, the borrowers, could review the CD. I'm not sure how lenders are counting these days, because I think they count, there's really only one day, from best I can tell in a lot of situations. That was written in there to accommodate that, so that the deals could really go through. But it only applies when the extension is needed for actually disclosing that CD to the borrowers. It's not just because the mortgage broker or the lender just sat around, didn't do anything, and waited until 2 days before closing, and then was scurrying about, and that loan hadn't even been submitted to underwriting for approval. And they don't automatically get 10 days, okay? You get up to 10 days. You get as many days as necessary. If they can disclose the borrowers on what would have been the closing date, they get 3 days, okay? So by the time you get closing date at 3 days, give them an extra day just to be safe. That's it. They don't get the rest of it. We built in 10 days because of mail, okay? Because under one scenario, they get, if you deliver it by mail, they get 7 days, and we added 3 days for the actual mail time, okay? And we looked at shortening the time frame. We can't, there's really no way to do it. So, but that's why it was there. I don't really get a lot of phone calls anymore about that. I don't know if you guys are having issues with it. From time to time, there's an issue with a lender. Okay. Force majeure, standard J. Let me tell you a little something. When you guys are bored or you need to fall asleep and you're looking for really exciting literature, grab the last few pages of the contract and read the standards. Nobody reads them. Your clients will not ever read the standards, especially with electronic signatures, okay? Let me tell you how those standards come about. Every time there's something in the contract that, oh, we need to save room, we need to shorten the 12-page contract that keeps growing, it is automatically, because you have the few who feel that it needs to be there, it all gets tossed into the standards. There's a lot of very critical information in those standards. Nobody knows about them, okay? Force majeure is defined in standard J. Here in Florida, the one we deal with the most, hurricanes, okay? If there was a tornado in a particular area, that would happen. I mean, it is acts of nature. It's defined in the standards, 9/11, okay? It applies, hang on. You get, the extension is 3 days after things are back to normal, and that's on lines 58 and 60. And it's really when the utilities have been restored or other services that are necessary. God forbid that we get, you know, a Katrina or an Andrew through here. I mean, you're going to be looking at 30 days or more. Real quick on the force majeure and the closing date, keep in mind when we're in hurricane season and they first announce the wave out and out, you guys really do need to pay attention to the weather, okay, during hurricane season. When there's a storm forming out there and you've got a deal that you're negotiating and then it's coming closer and suddenly it's now a named tropical storm, and whichever one it was this year that became a hurricane in a day, nobody knew about it. Here's the deal. The insurance companies will stop writing insurance, okay? That's really why the closings can't take place. Therein lies the problem. It's not the lenders, it's the insurance companies. So, and this is a conversation that you need to have with your clients. And oh, by the way, do not give them advice. Have the conversation with them. If you wait and that hurricane is coming and the insurance companies, you're within that cone or within the warning period and you cannot get insurance, you cannot close. If you want to make sure that you can close, then you need to right now go down to see your insurance agent, bind and pay. Pay. It's not just bind it, you have to pay for that insurance coverage. Now, there's nothing stopping you from closing on the closing date, regardless of what happens with that hurricane. The downside of that is, does the buyer really want to close on that house after the hurricane comes through if it demolishes it? That's why I'm telling you not to guide them in one direction or give them advice, because if the house is demolished, they're going to blame you. You get blamed for everything anyways, but they're going to blame you. So you just need to educate them, okay? If the storm goes through and you can't get insurance, you're not going to be able to close on that date. But if it doesn't hit, you'll be able to close this, you know, right after. Everything's ready. We just have to wait until you can get insurance. Make them be the ones who make that decision to get the insurance. Just remember, they need to talk to their agent. It has to be bound and paid. This last time around, I got a lot of calls for those who bound the coverage but didn't pay. So they didn't have insurance, okay? All right, occupancy and possession. This one's kind of common sense, right? Sort of. The seller is required to deliver occupancy and possession to the buyer at closing free and clear of tenants. This provision, which seems to be, yeah, everybody knows it, let's just skip right over it. And since there aren't any asterisks over here and no blanks to fill in, everybody just skips right over it, okay? Here's the deal. If you're the listing agent, the buyer, built in to this paragraph 6, the buyer has an automatic out. If that property has a lease, if that buyer has tenants in there and there is a lease, and you listing agent, seller, failed to provide a copy of that lease to the buyer, you're supposed to do it within 5 days. I'll make sure, I'm pretty sure that's what it has on here. Yeah. If you fail to provide that to them, buyer can, for any reason, maybe they got cold feet, it's now past the finance contingency. Oh, we didn't send them the deed. You're maybe 6 days away from closing. Buyer has 5 days to say, don't like this lease, I don't want the property. You're done. How are you gonna explain that one to your seller? So, best practice, there's tenants in the property. Get the lease agreement from your client right when you're signing that listing agreement, okay? Just like you get, hopefully, your seller's disclosures and all these other things, get the lease. That way you can provide it right away with the contract, okay? They have 5 days to review it. That's it, then you don't have to worry about it anymore. Okay. Line 68 does actually have it blank. So if there are tenants, make sure that you've checked that box, okay? A is telling you what the seller's requirements are. B is the one where you notify the seller that there are tenants in the property, okay? So if there are tenants, check that box. And if you don't know, for whatever reason, a lot of strange things happen, point that out to your seller. Do you have tenants? If you do, please make sure that you're looking at paragraph 6, line 68. That's the explanation that's on there. Okay, assignability. And then, are we good to take a break right after this? Okay. This one's an easy one. Here's my advice to you. Just say no. Check the box that says no. Why? Because you're agreeing. Okay, let's say you have a buyer. The buyer had a pre-qual, pre-approval letter, whatever, you know, you met them or the realtor told you all about them. You had 2 offers, but something told you, I'm gonna accept this one. I just think this is the one I'm gonna accept. Well, if that buyer can assign the contract to someone else, you've got a lot of folks right now where they're buying properties, and there's nothing wrong with this. It is perfectly legal. But you have a lot of folks out there who are the middleman. They're buying properties and they're flipping them before they ever even close, okay? So they want it to be assignable because while it's under contract, they're gonna find a buyer for that and they're gonna flip the contract. And that new buyer is going to pay them for the opportunity to buy the property. Got it? Maybe, maybe not. They're going to pay. Maybe they're going to qualify. Maybe they're not. What's the easiest thing? If really, it's a no-brainer when somebody's buying a property as an investment property, and it's husband and wife, John Smith, Judy Smith, and they suddenly decide, you know what? We talked to Mercedes and she suggested it's an investment property. You really should own it in an LLC. So the LLC is actually going to be the one that will be the buyer and the owner of the property. Nobody's going to object to that. Just have an amendment to the contract, okay? Basically, you're going to have, everybody's going to sign, old buyer, right? So husband and wife, then whoever is the president of the LLC is going to sign on behalf of the LLC, and the seller's going to sign. good to go, right? And most sellers don't have a problem with that. There's no issue with that. So say no, check no, because it's your safest bet all the way around, okay? We're gonna take a little break.
Do you want to do questions on this section?
Yeah, do you guys have questions? You stop me when we need to stop. No questions? Okay, Justina. I can't hear you, I'm sorry. I'm sorry, assignability, okay.
Yes. What about the case whereby the buyer wants it to go through the attorney? They have their
It wants to go through, let me,
through an attorney. Like sometimes some buyers want to everything to go through their attorney.
meaning the attorney is buying?
No,
Oh,
the buyer.
The attorney is reviewing the contract.
Yes.
And the attorney is advising them, make it assignable?
I had a case whereby the buyers, they were out of state, I never saw them, but everything I have to go through the attorney.
Okay.
So it's like they gave the lawyer the power of acting or something. I just have to go through the lawyer and the agent. And once I speak through the agent said, talk to the lawyer.
Okay. You can talk to the lawyer to find out as far as if the lawyer's representing the buyer, and the lawyer instructed the buyer. This lawyer, unless he has some additional power of attorney, can't really sign for the buyer, okay? The lawyer may have advised the buyer to check the assignability box because the lawyer knows the ultimate plan. So, but if they tell you that you have to deal with the lawyer, that's fine, you know where I am. You know how to reach me, Justina, so.
There's an addendum for
Hang
the
on.
seller's attorney and buyer's attorney.
Yeah, there is an addendum for anybody's attorney to review the contract. Okay, so that is, the contract is subject to them reviewing it. But I think that your situation was, it happened after the fact, something with the assignability provision. That provision isn't something where they can assign it to their attorney. If that's, it isn't at all. They can't assign the contract to the attorney unless the attorney is going to buy the property. Does that answer your question?
Yeah.
Okay.
Okay, my question is on the counter offer and the time frames. I got you said 48 hours. I'm sorry, you said second day, 2 days. Does that mean 5 o'clock on the second day or midnight on the second day? And what if the second day is a Sunday?
It is midnight, not 5 o'clock. And I want to confirm that, but I'm fairly certain that they get until 5 o'clock the following Monday. The reason I want to double check, Dara, is that runs counter to what the offer, when you have a specific day, which is really why that date, you know, if you say November 9th for acceptance of the offer, that is a date specific, and that does not, you don't get extra time for that. 2 days isn't a specific date, but it's all in the same section. So I want to confirm, but I'm fairly certain that it runs through the following Monday or following business days on business day until 5 o'clock. Okay? Yes.
My question is on the time of the effective date, where there's a contract, both signed, but there's an addendum that has to get filled out. So they're scrambling to get that done, and maybe finally 3 days later. Are we looking at an effective date when all addendums have been initialed and signed in?
If the addendum is checked in the contract, if that box is checked, yes. You do not have an effective date on the contract until the contract and all addendums are signed and delivered, okay? If the box isn't checked and it was an afterthought that they wanted to have the addendum, you had a valid contract when it was fully signed and delivered.
how did you do it?
In this happened to me once, I think we have to sign it. The buyer failed to deposit the money. And somehow the agent switched, was a breach of contract, the escrow deposit. So the agent also sent me a release form. Do we have to send a release form? If it's a breach of contract, can we just depart?
So here's the situation. On a 3-day time period, it's not worth getting into a legal battle over it. The reason why you should always sign the cancellation and release is because that gives direction to the escrow agent. See, the escrow agent is a neutral. They don't represent either party. They work with both parties equally. Did everybody hear the question, by the way? No? Okay, his question was, if the buyer fails to deposit the escrow deposit and they want to cancel the contract, they never made the escrow deposit, and they send a cancellation and release form, do you have to sign it? Did I get it right? And my answer is, in my opinion, you should sign it. Yes, they're out of the contract. I like neat and tidy. I call it simple, stupid. There's no mistakes. But the reality is, let's say, and I know how you operate, right on top of things. The contract has already been delivered to the title company. They've already ordered the search because it's a quick turnaround, okay? You're just waiting on the escrow money. Well, the contract, now signing that, you have the end of the contract, okay? So if ever an auditor comes in and they're auditing the file, it's not just sitting there as an open file. You have the end of the contract. So I understand where you're coming from because it doesn't really make sense from a logical standpoint, but we lawyers aren't necessarily logical all the time, and we like more paperwork. So it's, that cancellation and release or termination and release document, it ends the deal. And it's just one page. So, yeah. It just makes life easier and really better for you, better for everybody, because now here it was, they didn't do it. But you guys, make sure you stay on top. If you're representing the seller, stay on top of that, okay? Too often I get the call when the deposit wasn't made, these buyers were never serious about it, and the property was taken off the market for 3 weeks. What do? I get the deposit. Sure, there's no deposit. If you want to go chase them, good luck. I'm sure a lawyer will take the case on. There's not enough money. Yes.
Occupancy and possession. So what if the seller intends to sell, but has an adult family member living in the home, but without a lease, because it's an adult family member? And the adult family member decides they really don't have anywhere to go. So they're kind of squatting.
Okay.
And it holds things up and makes it all tangled because they weren't tenants in the property.
Yeah, they are. The
Well,
law looks at them as
they're
tenants.
tenants without a lease. So
Here's the situation. And the flags and the bells that went off in my head was the word family. Trust me, guys, anytime that it's family, that's when you really need to make sure everything is documented. It's always a business transaction, and if somebody takes offense to it, you can very nicely and politely, well, I probably can't. You can ask my husband to do it because he can very nicely and politely say it. I'm not that nice. But when everything's in writing, it's amazing how well everybody gets along. The contract says, okay, we have to follow this. What you need in that situation, the seller needs to hire an attorney. They really do, unless the seller wants to do it themselves. But how you get, we'll assume they pay rent in some form or fashion. I'm assuming they don't.
well, this was one of the agents in a previous brokerage that I was with, and I was a branch manager, and I was trying to be proactive, and I said, why don't you try and help the family member find a rental and get paid both ways? So it was kind of but it could have gotten sticky had they not you know, I was like, help him, take him out, find a rental, you know, do something like that. Try to ease it along, grease the wheels a little bit. But I thought it was gonna get like stupid ugly.
Well, brilliant suggestion to keep it all nice. If it's not that nice, here's what happens. We'll assume it's a month-to-month
That's what I wanna
tenant.
know. What if the what if?
If it's like that, what should happen is that tenant needs to have a 15-day notice to vacate. And at day 15, they have to be out of the property. If they're not, a lawsuit for eviction can be filed. If they're not paying rent, you're not gonna have any damages dollars-wise. Now, there are some cases that look at that as what we call a case in ejectment. And that is, in certain circumstances, you invite someone into your house and they have your full permission, and then they refuse to leave. Okay, we really don't want to fall into that, because if you file a complaint for ejectment, they have 20 days to answer. A lawsuit to evict a tenant, they have 5 days to answer the complaint. If they don't answer, then the judge will issue the writ of possession. The sheriff has to go out, post the writ. Don't ever change locks. Ever, ever, ever do not change locks. But the sheriff's office goes out, posts it on the door, and 24 hours later, the sheriff's deputy will come back, and, you know, whoever can meet them there, and that's when they can change the locks. So there is a way, it's just not a nice way. Okay, any other questions? Yes.
You were mentioning the TV mounts in the wall. Let me give an example of the mount is removed and you know, it's excluded as personal property. The holes in the wall, should those be discussed on being patched, or it's okay to walk into a house with bullet holes in the wall? What's kind of the norm in that situation? Because I usually tell the seller, you know, if you do take the mount off, you should patch behind it.
All right, so it's not a legal answer, but if the seller really wants to sell the house, make it look nice, fill in the holes. They do look like bullet holes, and you might scare off a few people. But yeah, if you bring up another really good point, make sure that when you're walking through, and this is something I forgot to mention, so you have to list things on MLS, right? Think about that. Grab your MLS sheet as well when you're going through with the seller, okay? Because if it's at that point that the seller is telling you that he's taking that mount off, make sure that there's no reference to it on MLS, because the TV's gone, the mount's gone. If it's all there, then you have to be very specific about what conveys and what doesn't. If your question is more along the lines of, well, the buyer comes in and sees holes in the wall, are they entitled in some way to have that mount back? No. When the offer comes in, the buyer is entitled to what is in the property at the time the offer was made, okay? So they walk through the home, they have 2 refrigerators and a freezer. Offer comes in. The seller meant to take out the freezer and the extra fridge. Too late. You may want to try to negotiate that with the offer, but at that point, the seller cannot just sign the offer and remove the fridge and the freezer, because it's
Or
at,
replace it with junk.
yes, or replay. I have a lot of people that I hear, you have cell phones, it's an unlimited number of pictures, right? Go around and take pictures so you know actually what's in there. Usually there's a really, really nice fridge in the kitchen, and the one in the garage is old. So, all right, guys, why don't we take a break? It's almost 10:30. Oh,
Sorry.
one more question.
2 quick questions. First off, when you're talking about the purchase price, is it okay to put balance in that last column, or should you write the actual dollar amount?
No. Thank you. Don't write balance. Do not write balance. Remember what I said? It's an easy calculation. Don't worry about all the added, expenses that come along with it. Offers $100,000, $1,000 deposit, they're gonna put down 10%. You can do that math and put down the total dollar amount.
The next question, really quickly, what would you advise for if there's actually like a table or a couple pieces of furniture as a part of the sale? I was told it should be put on a separate addendum. What would you advise if there's furniture as a part of the transaction?
Okay.
I know that
That
can
is a
vary very
separate
quickly.
agreement, okay? You can, the reason why you don't wanna add it in the contract sometimes is because the lenders are a little sketchy about that, depending on who you're going with, and they really don't wanna see the personal property or anything like that. Just make sure you write it somewhere. Add it in the additional terms if there's no concern. If it's a cash deal, you can add it under additional terms. It is not legal language you have to add. You can just add dining room table and chairs and chandelier, all convey to seller or to buyer, and everybody signs it. Okay? All right, I've got a lot of antsy people. Bathroom time. Okay? Thanks.
Yes. Yeah, 17.